Hello, good afternoon, and welcome to Your Mediation. My name is Sabrina O'Keefe. You can just call me Sabrina. How would you both like to be addressed?
Roji.
Roji?
Yeah.
Mrs. Youngman.
Mrs. Johnme? All right, sounds great. All right, so I have two agreements here. These are the agreements to mediate. And so I had sent them to you earlier, but if you could just sign them now to let me know that it's okay to proceed with everything, that would be great. And while you're doing that, I also wanted to remind you that you agreed to pay the fee at the end of this session.
Got you.
Alright. I also wanted to first familiarize you with the location that we're at, and so if at any point you need to use the restroom, it's across the hall. We have some vending machines that are downstairs that you're able to use during break times, and so if at any point you need those, please let me know. I may ask that you make sure all your cell phones are turned off throughout this, so we can try to do this without any distractions. Alright, and then I just want to make sure, are you comfortable in your seating, lighting okay, temperature,
Everything's perfect.
everything good? Okay,
Good.
awesome. So, we have this room scheduled until 4 o'clock today, so we've got some time. Does anybody have any time commitments that would have you needing to leave prior to that time?
No.
Okay, great. I just need to make sure, are you capable of and can you make decisions regarding the solution of this matter if you deem appropriate? So in other words, can you make a decision about the situation we're talking about without having to consult with somebody today?
Yes.
Yes, awesome. I'm now going to make what mediators call an opening statement. My opening statement will tell you about your rights and entitlements, what to expect, what will occur here, and to give you a heads up as to what to anticipate throughout your mediation. After I'm finished with my opening statement, I'd like to hear uninterrupted opening statements from each of you. Please tell me what you think, if you need to bring me up to speed with anything, so I can be as effective as possible in helping you make the most of this mediation. I assure you that your opening statement will be uninterrupted. However, I will be taking notes and may stop you to make sure that my notes are accurate. If there's anything you'd like to say during the other party's opening statement, I request that you take notes on paper that's been provided and come back to that later. So first, I want to go over what is mediation, what is a mediator. So mediation is negotiation with the assistance of a neutral party, a mediator. I'm here to help you to negotiate. Mediation has been around for more than 5,000 years. Everyone at this table and or has been a mediator. If you've gotten into the middle of people having any kind of fuss, family, children, and ask what's going on, then you've been a mediator. So the only difference between you and me is that I don't have any personal interest in this mediation. Mediation is very successful in 3/4 of all matters going on to mediation are settled. The purpose of this mediation is to help you, if possible, find common ground in the matter so that it can be resolved in an agreement if you so choose. So you have some basic rights and or entitlements throughout this mediation. First, confidentiality. I will keep all that I hear in the mediation confidential and will not share any of it with anyone. I also request that you keep what is discussed confidential as well. Most states consider mediation as settlement negotiations, thus protecting and holding anyone said inadmissible in court. However, there are some exceptions of what I call the mediator's Miranda warnings that I cannot keep confidential and must reveal. So, if there's any threat of violence or harm to anyone, especially children or the elderly, I will need to report it. If anything comes up throughout the mediation, that past or present abuse of any kind or a threat of future abuse is possible, that might also be reported. If throughout the mediation, a plan for a crime, someone commits a crime or attempts to commit a crime, or you're trying to conceal an ongoing criminal activity or threaten violence, those also might be reported out. Does that make sense?
Yes.
Awesome. Okay, second, this is voluntary. This is a voluntary process. If this is not meeting your needs, you may leave at any time. If you've been ordered here, you're required to negotiate in good faith. If you think you want to leave, I request that you confer with me first. You don't, however, and I might have, you don't have to, however, and I might have a perspective as a neutral that may be helpful to you so that a decision that you would make would be with all the available information. By the way, anything I say in this mediation is an invitation for you to consider and nothing else. Also consider that you've designated time in your schedule to be at this mediation, and for the most, it's costing significant sums of money, so I encourage you to use this time to the fullest extent possible, and to see how far we can get in resolving, or at the very least, limiting and or clarifying the issue that you're in your conflict. Third, neutrality. You're entitled to a neutral assistance in this mediation. I can't just say I'm neutral. I believe I must prove it. So first of all, I don't recognize any of you. Do any of you recognize me?
No.
Let me take a step further by telling you something about me as if we hadn't had any contact or relationship. I also work for the Center for Leadership and Service. Would any of you know me through that?
I've heard of you.
Alright, so if you've heard of me, is it okay if I still proceed as your mediator as neutrality and stay neutral?
Yeah.
Yes.
Okay, great. Again, let me remind you that I have no power and or I cannot make any decisions in your matter. I wear only one hat here, and that is as a mediator, an individual who assists parties in negotiations. Right. Fourth, capacity. Do you have the capacity to conduct a good faith negotiation, make decisions for yourselves, including a decision to end the mediation if necessary, as well as able to sign an agreement if you reach one? And is anyone under the influence of alcohol or drugs?
Yes to the first part, no to
Yeah,
the second part.
exactly.
Okay, great, perfect. I will not be giving you any legal, financial, or specialized advice. If you want or need such advice, you have agreed by signing the agreement to mediate to seek it from an appropriate resource of your choosing. In no event will you seek it from me or rely on me for any advice of any kind. Additionally, you have agreed that you will not call me as a witness in court if this matter is not settled. Correct?
Correct.
All right. So what's going to happen? We are all together in this so-called joint session. We will remain in this session until all opening statements are presented. We remain after the opening statements in a joint session if you are okay with this, or a caucus may be called. A caucus is a private meeting. Any of us may call a caucus. If you wish to speak to me privately, or I wish to speak with you privately, a caucus will be called. If you wish, we go to caucus and we'll do so immediately after the opening statements. If I meet with one party in a caucus, at the conclusion of that meeting, I will meet with the other party. At the conclusion of those meetings, I will ask if there's anything that you wish for me to hold in confidence. Whatever you request I hold in confidence, it will be done. There may be a disparity of time that I spend in a caucus with one person as opposed to the other. That does not mean that I'm forming any favor or affection towards one party over another. The reason for the time disparity is that it may take longer to say what one has to say as opposed to the other person has to say. Also, when I'm caucusing with one party, I may request that the other party use that time to think of some things that might work for them when you am in the mediation and that they would consider. That way, we'll be working towards a resolution during those times. Consider the following. When I'm in a caucus with you, I will be bringing a message of the other party to you. Conversely, when I'm in with the other party, I'll be taking the message to them. So please see me as a messenger when I'm not the message. Okay? So please see me as the messenger, not the message. Also, be aware that negotiating is more flexible. Also be aware that negotiating is a give and take process. As such, most folks don't get all that they want. I request that you be more flexible than you were before you came here today. Personally, I like to think positively and invite you to do the same. Maybe you can find some common ground and hopefully reach agreement and clarity and or limit the issues that you'll be able to resolve the conflict and move on in your lives. Keep in mind, in mediation, you have 100% control of the outcome. If you go to court, you have little control, or at best, 0% at the worst. Additionally, if there are more than one session, and I have contact with either party, whoever may initiate that, either me or the other party, I will consider it a caucus. After that caucus, I will contact the other party and provide them an opportunity to have their caucus. Confidentiality will continue to apply in the caucuses. If you reach an agreement, settling some or all issues will be written up. If in fact it does reflect understanding, all will sign it, sign the original, and I will make adequate copies for everyone and whoever court or anybody else that's requiring one might need. Also, if this matter is in court and all those issues are settled, the agreement usually resolves all the court's concerns. If you reach a partial agreement or not, I suggest that we explore some available alternatives, like future mediations, arbitration, trial, other things. Hopefully we can discuss all the potential outcomes. Thank you for listening to my opening statement. Does anybody have any questions or comments? All right. May I have your opening statements?